2, 1.
Oh, yes, oh, yes, oh, yes. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning to the lawyers. After we call the case, we're going to discuss the order and the time allotments in this case. But right now, we want to make sure that if there are any problems develop during the hearing of this case, would y'all just please let us know so we can take care of that immediately. We don't want to do anything without someone having full knowledge and being a part of it. Also, this case will be presented as you in court yourselves, except you don't have to stand in your presentation unless you so desire. Somebody may be more comfortable in standing and doing their presentation. That will be all right. But if you're not, if you don't want to, you don't have to. Your panel today consists of Judge Frison, Judge Davis, and myself, Judge McClarity, who will be presiding. Okay. Let's go. Madam Clerk, are there any preliminary matters or any motions first before we start?
No, Your Honor.
Okay. Will you call this first case then?
Joseph Riccardi versus Carl Little Construction Company, Inc. et al.
As this case has been called, let's look at the time situation. Mr. Was that Jesse for Mr. Ricardo?
Yes, sir.
Your total time you will have is 15 minutes. Is that correct? I mean, 20 minutes. Is that correct?
Yes, Your Honor.
Okay. How do you want to spend your 20 minutes?
I'd like to do my first 15 minutes in argument and reserve 5.
Okay. Now for the defense, we have two attorneys that will be arguing on the defense side. Is that correct?
Yes, in there, I represent Bridgewater Homeowners Association.
Okay.
We are both an appellee and a cross appellant. We are with Mr. Jesse on his argument, and then I have a separate argument that I'm opposing Mr. Jesse.
Okay.
But I'm going to take my time, if it's with the court's permission, at the end of Mr. Owens' time.
Okay. Now, how much time will you be spending? This side was given an extra 5 minutes. I would like to use the 5 minutes. You just, so a total amount of
5 minutes.
A total amount of 5 minutes for yours, okay? And then for the other appellee?
Your Honor, I think 15 minutes is the time that I was allotted.
Okay, so you're going to use the total 15 minutes.
Well, I may or may not, Your Honor. It just depends on where I stand in my argument.
Okay, and you'll be doing your argument first then, correct?
I will be following Mr. Jesse, I believe.
Okay, okay, good. Okay, then, so we're straight on the time then, okay? Then let's go ahead and hear the case for the appellant first, Mr. Jesse.
May it please the court, I'm Tom Jesse of the Washington County Bar. I represent Mr. Joe Riccardi in this matter. Mr. Riccardi purchased the house that we're going to discuss today in 2007 and moved into it in November of 2007. I want to point out a little anomaly at the beginning because it's not always clear when you read about these. This is a condominium development. It's defined as a condominium development in the master deed regulations created by the developer, who was Mr. Little, Carl Little Construction Company. And as a condominium development, most of these regulations would make sense, except for the fact that my client happens to own a single family residence. So I don't want to get confused. He has one building that's just his house in amongst other construction of, I think there's as many as 4 in some buildings, sometimes 2, but it's not your traditional high-rise condominium. So I wanted to just point that out to the court at the beginning. But it's clear that the regulations, bylaws, and homeowners association documents apply, and this was deeded to Mr. Riccardi under the master deed. We have 2 issues today. One, the trial court dismissed Mr. Riccardi's claim and Bridgewater's claim, Mr. Johnstone's client, against Carl Little Construction Company, who is the founder of the development, created the documents, and constructed my client's house. The basis, Judge, excuse me, for the dismissal was the statute of limitations, which is 3 years for property damage claims, as well as the statute of repose, which is 4 years for any and all claims relating to construction development of a property like this. Mr. Johnstone and I did not want to repeat our argument, so I'm going to address first, and I'll be the only one to addressing the summary judgment motion granted to Mr. Little, which is Mr. Owen's client. It's our position that a question of fact does exist for a trial of this matter. As the court is aware, if there are any issues of material fact, then the court should deny summary judgment and allow the trial to proceed to the jury and for the jury to decide, or of course, a non-jury trial. Additionally, under the statute of repose, if there is a actions on part of the contractor to fraudulently conceal a cause of action that my client would have as the purchaser of the house, or that Mr. Johnstone's client would have as the homeowners association, because they are required to maintain the outside of the building, including my client's single family residence, then there would be a sufficient question of fact to allow for a trial on the merits. The court must look at the facts in the light most favorable to the non-moving party, which is Mr. Johnstone's client, Bridgewater, and my client, Mr. Riccardi. Very simply, it's our position, and the facts will bear out in both our brief and the earlier papers filed in this matter clearly reflect, there is no dispute, that Mr. Riccardi began having problems at his house with what Mr. Little would describe as standard punch list items. Mr. Riccardi testified that he would be seeing cracks. Problems began to develop in the walls, separation of the window areas, and the testimony is undisputed that Mr. Little regularly told Mr. Riccardi, "I'll send somebody to fix it. Don't worry about it." I think his quota is, according to Mr. Riccardi, that this is just plain old East Tennessee construction settlement. There's nothing wrong with your house. We're going to fix it. Well, as the facts will show, and undisputed, the construction got worse. There was separation in the back patio area from the house. There began to become questions about structural issues, which again, Mr. Riccardi confronted Mr. Little, the defendant, Carl Little Construction Company, Inc., and said there are problems. Mr. Little continued to say these are just East Tennessee problems. There is nothing wrong with your house. You have a good house. Testimony is noted in our brief Mr. Little sent a different contractor over to help him fix up some of the damage to my client's house by doing some caulking area at the patio. And that contractor said he would continue to come back and fix it, probably settlement cracks. So we continue dealing with these problems. There is no question. It's 4 years past the day that he took possession of the house. After that, he discovers that not only did Mr. Little mislead him by saying there is nothing wrong with your house, he finds out the foundation is failing when Master Dry comes. He develops issues relating to the foundation. The patio on the back is beginning to separate. Bridgewater, is alerted and does coarse samples in the floor of the garage. The front driveway is separating from the front door of the garage. Those issues become apparent. And after it's obvious there is much, much more, Mr. Riccardi files his lawsuit.
Let me ask you a question. Those issues became apparent after the statute ran?
Yes, sir. After the 3-year and after the 4-year, in the sense that those issues, because they were under the foundation, it was discovered that there is a completely failed concrete slab under the house that is actually floating on the uncompacted soil under the house.
What is your position regarding the fraud and concealment? Are you contending that the fact that he continued to assure your client that he had a good house, or that these are just minor issues involving settlement, will that in itself make out your fraud, or do you have other proof?
Well, it was not just the assurance that you have a good house, don't worry about it, it's just East Tennessee settlement. The fact that the construction company had knowledge of this totally failed slab under the building, because they're the ones that poured it and put it there, and how it impacted the foundational construction of the house is a question of fact.
Mr. Jesse, and maybe I misread this in the record, but I thought that there was a subcontractor that did the foundation work, and Mr. Riccardi said he thought it was done correctly by the sub. Is that wrong?
No, ma'am, you're correct in that the contractor hired a sub to pour the concrete, which is usually standard construction. The slab failed, but Mr. Little said he was at the job site regularly. So the two
I said Mr. Riccardi and I meant Mr. Little.
Yes, ma'am, I knew you meant. But Mr. Little also admitted that he knew the soil wasn't compacted, but he did not ever disclose two very material issues, and went on by compounding the problem by saying, well, it's not, I didn't compact the soil. It's not that I put this slab under there or the foundation is a problem. It's not that because of the non-compacted soil, this is standard East Tennessee, good house, good construction. This house is just normal settlement. Well, in fact, it did not in any way end up being normal settlement. As noted in Mr. Johnstone's brief, the engineer says that it's going to be a substantial cost to repair. I would refer the court to the Jenkins versus Brown case, which is a Middle District case that Judge Cope authored when he was on the Court of Appeals, and our East Tennessee, they talk about cases from all the districts, but that case is almost identical. And what's interesting in that case is that the Jenkins who brought the lawsuit against the contractor are the second owners of the house. So the Court of Appeals said there was a question of fact when, in fact, the contractor built a house, other people owned it. They owned it for a couple of years. The Jenkins then buy it and discover what they contended was hidden information that caused them to not proceed to a lawsuit, their cause of action. They allowed it, and the Court of Appeals upheld the jury verdict in that case. In that case, the trial judge allowed the case to go forward as a question of fact. So respectfully, given the statements, which clearly Mr. Little did not deny about compaction, this slab, other material defects that he obviously knew if he had looked at the client and announced, oh, gee, your house is built on a slope here with bad soil and there's a floating slab underneath it. I submit anybody, it is a question of whether at that point, if somebody had been given that information, they wouldn't have then proceeded. So respectfully, on behalf of my client, Mr. Riccardi, and of course, Mr. Johnson can speak for himself, but Bridgewater is faced with dealing with the outside of our house as the homeowners association. And certainly they were never told of the situation. They find themselves as a homeowners association, much like Mr. Jenkins did in that Jenkins v. Brown case. They're kind of the second owner behind us as such, and they've got the same problem. So we believe that it needs to be presented based on material facts. There is a dispute. What did Mr. Little do? When did he do it? What did he know? When did he know it? For a jury to decide whether or not he fraudulently concealed a cause of action relating to the construction of this house. Does the court have any questions on that issue? As it relates to the Bridgewater issue, all we're saying, and respectfully, our brief pretty much addresses it. I may address some in my 5 minutes, but we contend that the judge limited what Bridgewater had to repair. When you look at the documents, that's all you have to look at to determine what Bridgewater's responsibilities are. When you look at those documents, they are required to deal with soil and water erosion problems, soil shifting, outside maintenance of the buildings. And respectfully, you can't, when you're dealing with soil problems and this building shifting, the back patio and the sunroom is coming off the back, well, you obviously are going to have structural problems inside the house. The outside problems are what's causing the inside problems, and it's our position that the trial judge should not have limited what they have to repair. Any questions from the court?
I hear none.
Thank you all.
Thank you. You have your rebuttal. For the appellees.
Thank you, Justice McClarty. Chris Owens here on behalf of Carl Little Construction. For purposes of the statute of repose, the accrual of the cause of action is the date of substantial completion of the property, which I believe is undisputed in this case to be October the 26th of 2007. So therefore, under the statute of repose, any action for property damage would have to be brought no later than October 26th of 2011. And for defects discovered during that fourth year, you get at most an additional year, which would put an absolute end to any right of recovery for this property damage of October the 26th of 2012. Suit was not filed until September the 9th of 2014.
Fraud and concealment, does that extend the statute of repose?
Yes, but it's not applicable here, and I'll address that directly, Your Honor. But the point here is not what Mr. Little knew. It's what Mr. Riccardi knew. Mr. Riccardi knew in year one, cracks were forming in different areas of the house. He raised the issue with the homeowners association about these very problems that he asserted in his complaint. In year 2, 3, and 4, he informed the homeowners association about cracks in the interior, cracks in the exterior walls, soil deterioration, failing support columns, the separation of the back patio. And he even went so far as to make a warranty claim with Mr. Little during year 2. So, Your Honor, the fact of the matter is, Mr. Riccardi knew at all times that he had ongoing property damage and took no legal recourse to address those until long after the statute of repose had expired. And, you know,
What about if Mr. Little had knowledge and he concealed it, continued to reassure Mr. Ricardo? What about that?
It's not, Your Honor, it's not concealment of the defect, it's concealment of the cause of action. So there was nothing concealing all of these things that Mr. Riccardi was complaining about: the cracks, the separation of the patio, the soil deterioration, the columns, all of this stuff was front and center to him. He knew about it. He knew it was ongoing. And, you know, this is not a case where, you know, a contractor's called out to do a punch list item and he notices some huge problem with the foundation and hides it and then goes running off into the sunset. That's not the case at all in this case. What happened here is what Mr. Riccardi knew. He knew that there was ongoing property damage throughout the entire period of the statute of repose. And Your Honor, with respect to, you know, this business about, you know, compacted fill dirt or uncompacted fill dirt and foundation problems, the case law in interpreting the statute of repose and fraudulent concealment, defects and even concealment of defects in the original construction do not constitute concealment of the cause of action.
Counsel, excuse me for interrupting. You indicated that in year 2, this was presented as a warranty claim. Prior to that, were these problems presented as a punch list problem?
No, I'm not sure that there was ever a quote unquote punch list per se, but yes, during the very first year, cracks were appearing in various places. Mr. Riccardi would make complaints about those cracks to Mr. Little. Mr. Little would attempt to fix them, and they would continue to occur such that Mr. Riccardi continued to complain about them. He went to the HOA about them. Then problems started to get worse. So the point is, there was nothing concealed from him. He knew this was ongoing the whole time. And the only, you know,
Did he have the knowledge of the extent of the problem, though? The fact that the problem involved the slab, something that is not visible. Did he have knowledge of that?
Your Honor, I don't think there are facts in the case that that suggest that. But the point is, it's not the date when he learned about the problems with the foundation when the cause of action accrues. This is a statute of repose. The statute that cause of action that accrued the date of substantial completion, which was October the 26th of 2007. The fact that he learned about these issues in 2014, the only way that he gets to file his cause of action is if he can prove that there was fraudulent concealment. And the key there is, Your Honor, fraudulent concealment does not apply to defects in the original construction. And it has to be fraudulent concealment of the cause of action itself. And in this case, it's impossible because Mr. Riccardi knew all along he had ongoing property damage at his residence.
Wouldn't it be a jury? I'm just asking, would it not be a jury question if the contractor had knowledge of the extent of the damage, but he assured the buyer that this is no problem at all? These are minor, ordinary situations.
That's Your Honor, that may be a misrepresentation, giving all deference to the plaintiffs in this case, but that's not a concealment of the cause of action.
What would be what would constitute a concealment of the cause of action under the facts of this case? What would he have had to have done?
Well, for instance, let's say that Mr. Little went out there to repair some cracks complained of and noticed this issue with the original construction of a defect in the foundation and took a covert action, affirmative action to then conceal that. That perhaps would qualify as fraudulent concealment. He's concealing he's got knowledge of it and he's then concealing it from the homeowner. But in this case, he had knowledge that there was damage ongoing to his house. And Your Honor, there's a reason that this exception for defects in the original construction not being a basis for fraudulent concealment. And that's because almost every component, structurally certainly, of a home is concealed. The wiring, the plumbing, it's all behind finishing. It's behind sheetrock. Foundation, footers. By nature of construction, this stuff is concealed. So you can't say, well, just because, the homeowner couldn't see it, that the builder engaged in some sort of fraudulent concealment. The fraudulent concealment is when the builder takes affirmative actions to conceal the cause of action, not the ongoing damage. And the going even further, as a matter of fact, in this case, that didn't happen because Mr. Riccardi knew that this was ongoing. And
were excuse me for interrupting, counsel, were the attempted repairs, were those attempts made by Little Construction or the subcontractor that actually did the foundation work?
Well, my understanding is that Mr. Little would send workers of his out to perform some of the crack work. I think that there was never anything about the foundation. That was never an issue until 2014 in terms of what Mr. Jesse referred to previously. I mean, there was never any attempt to fix a foundational issue.
Thank you.
And, you know, the Liggett case that we cited, which is 2008 Westlaw 836-115, is virtually right on point to the case that we're talking about at hand. And in that case, I wrote this down. The Court of Appeals stated that in light of the overall picture of the information known to the Liggets prior to March 2001, however, this court has reached the conclusion that they were on notice that there were significant and pervasive problems with the construction at the home. And that's exactly what we have here. Mr. Riccardi had, at giving him all the benefit of the doubt, had until October the 26th of 2012 to file a lawsuit for property damage. And that was not done. And absent being able to prove that Mr. Little concealed the cause of action, not defects in the original construction, but the cause of action, meaning that there was ongoing property damage, this case is simply, the right of action is extinguished as a matter of law under the statute of repose. And I guess lastly, the Prescott decision, or that was relied on, is certainly entirely distinguishable, and the Liggett court that we've relied on, which is absolutely directly on point on all fours, distinguished that lawsuit. That was a lawsuit that was dismissed on the statute of limitations, not on the statute of repose, and it was, the court simply held that the suit was filed July the 11th of 1980, so the accrual date for any causes of action that would have been barred would have been July the 11th of 1977, and the court held that the mudslides complained of occurred in May and September of 1979. So there was nothing to put them on notice prior to the accrual date of July 11th, 1977 to file suit. Now, again, that's dealing with the statute of limitations, not where you have, as with a statute of repose, an actual defined accrual date of the substantial completion of the home. So we have a start date and we have a known finish date. And there's one single avenue of escape, and that is whether or not Mr. Riccardi, whether or not Mr. Little concealed these, as the Liggett court stated, these significant and pervasive problems with the construction. It's ongoing. So as a matter of fact, Mr. Riccardi knew that he had significant problems ongoing with this house. The fact that he didn't know every single little possible defect, I don't think is significant, Your Honor. He knew there were issues.
Thank you. Thank you, Attorney, Counselor. I think your time is up. Isn't that correct?
If it's up, it's up, Your Honor.
Okay. So we'll move on.
If the court please, I'm Frank Johnstone from Kingsport.
Yes, sir.
I represent the Bridgewater Condominium Property Owners Association, which I'll refer to as the association. The association is both an appellee and an appellate in this case. Bridgewater agrees with Mr. Riccardi that the grant of the summary judgment was an error. And in keeping with Rule 35, I don't plan to address that.
Yes, sir.
Let me address the appeal that as it directly applies to Bridgewater. The trial court found that the association had a duty to repair Mr. Riccardi's rear porch, even though that porch or patio supports a sunroom above it. If you look at Mr. Cross's report, which was filed in opposition to the summary judgment, you will see that that's not a simple repair. It could be quite expensive. Although the association was disappointed in that ruling, they were reconciled to it and did not file a notice of appeal. It wasn't until Mr. Riccardi appealed that we thought it was essential to protect any rights we might have if the summary judgment was reduced. Now, Mr. Riccardi's appeal challenges the trial court's decision, but he did not file the record of the critical hearing on February 19th, 2020, or 2000, the transcript of the February 22nd, 2019 hearing. And without that transcript, we don't know the extent of the damage to the house. We don't know what anybody testified to. We have an example. For example, Mr. Riccardi refers to the testimony of attorney Timothy Scott in his brief. He does not cite to the record. He couldn't. And the question arises, what else did Mr. Scott testify to? In addition, Mr. Cross, the court noted, and a surveyor also testified. Mr. Cross testified about the condition he found in the house, which you can see in his report, again, which was filed with the motion in an opposition motion for summary judgment, that he found 2 slabs inside the perimeter of the house. His testimony could affect whether we're talking about the inside or outside, but the court found that Bridgewater's only obligation was to fix the back porch, as substantial as it is. And it's our position that without that record, you have to affirm the decision of the trial court. Now, let me briefly address something that Mr. Jesse suggested in his reply brief, that you could find all the necessary documents basically attached to his brief. We don't think the court ought to do that. And we don't want to waive the argument that the court should affirm on the basis of no record. But if you're hesitant to do that, a quick look at those documents will not change the result reached by the trial court. Again, don't necessarily want you to go there, but it wouldn't change the result. In particular, he cited the things that define the common and limited elements. There's a section of the restrictive covenants he's referred to that the judge found extended our obligation to the back patio, not simply the front. The references to the bylaws could not change the definition of limited and common elements. And if there is some conflict, the master deed and the restrictive covenants would control. But I'm only saying that to say that we'd probably come down to the same decision, but we're without a lot of explanation about the condition of this house, this development, and things that you really would need to have to examine this closely. So we, on behalf of Bridgewater, we would urge the court to reverse the summary judgment and to affirm the judgment of the trial court, limiting our duty to the back patio. Thank you.
Thank you, sir. For the rebuttal, for the appellant.
Yes, Your Honor. In addressing Mr. Owen's statement on behalf of Mr. Little that, well, you're supposed to know because you have cracks in your concrete that you have substantial structural defects in your house. He doesn't deny that Mr. Little continued to represent the cracks as the contractor, the educated, trained, licensed person, were nothing but cosmetic caused by East Tennessee settlement. He has to be afforded the fact that He knew there were 2 stabs. His company, which is Carl Little Construction Company, Inc., the defendant, built the house. When asked what's causing this, he doesn't say, I didn't build it according to code. In fact, you'll see in my brief, Mr. Riccardi testified that the house was built according to all building codes. Mr. Riccardi testified that he turned him in to the state over construction issues. Respectfully, he concealed what his company knew, but most importantly, that's a question of fact. The jury might say, quote, well, Mr. Riccardi was just not very bright. He should have figured out when he had his 4th crack, he should sue somebody. But that is a question of fact as well.
Mr. Jesse, what about the Liggett case? It seems pretty similar, where you've got homeowners complaining of cracks and things of that nature, and you've got a builder saying it's just settlement, and ultimately it turned out to be a little more significant than that. The trial court said there's no fraudulent concealment there.
Well, when he tells them, and additionally, that it's just settlement, Mr. Owens might be right, but it's a question of fact. The jury has entitled to hear, well, what was the extent? How many times did they come back? Who said what? And there is no question that Mr. Little testified, well, I thought everything was okay once he gets sued. Bottom line is, I thought everything was okay. I knew there were substantial problems, that if I got sued, I was going to have to almost halfway tear that house down. So respectfully, the standard of, is there a question of fact? This is for the finder of facts to decide, not for summary judgment, respectfully. As it relates to Bridgestone, Mr. Johnstone had the right to add anything else he needed to the record. We submitted detailed proposed findings of fact and conclusions of law on both sides. The engineering reports are all in the record as to the problems of this house. It all turns on what is the legal obligation of the homeowners association. We don't need testimony, because since the day the complaint was filed, the master deed, the restrictions, and the homeowners association bylaws are filed with it. And we cite from them extensively, not only throughout the trial court, but also on appeal, that Mr. Johnstone's client has very specific responsibilities. And the court limited it to the front patios, the back patio, which the homeowners fought about. They didn't want to do the back patio. The court said the front patio, the back patio, which deals with the sunroom, because the piers for the sunroom are in that back patio. And there are cracks throughout the house that are the result of the structural problems that the homeowners association must maintain. You'll see in my brief, I said they're supposed to have insurance to cover it. Unfortunately, apparently they don't in this case. But the bottom line is, a clear reading of the legal documents defines exactly what they're responsible for. The fact that you have the engineering report, it does say all the problems and what has to be fixed. We're saying that the judge read the legal documents and limited their responsibility as defined in those documents. The court has nothing else. That's all I have.
I hear no other questions. Thanks to both counsels for your presentation. We will duly consider this case and issue opinion during the due course of our actions. Thank you very much. The lawyers may be excused.
Thank you.
Thank you.
This honorable court is in recess until 10:30 a.m.